OTC?
The OTC, where the OTC used to be.
Used to be, not there anymore.
His mother was a celebrated assistant counsel. He became member of Kenya Justice. Yeah, that was the last one. He became a bigger lawyer.
You became a bigger one.
You get a position.
Where he is in the league of those who get
Yes.
also.
Given very short notice, but we are happy you are here. We wanted to dispose of this matter so that we can move on. This is the ruling of the court signed by all the judges. The notice of motion dated 9th March 2018 seeks a stay of execution of the Court of Appeals order of 2nd March 2018 allowing the respondent's appeal and remitting the petition to the High Court for hearing and determination on merit. The application is based on the ground that the petition to the High Court, having been filed on the 5th of September 2017, the 6-month period described by Article 871 of the Constitution and Section 75(2) of the Mr. Nyamodi urged the court to grant a stay of execution so as to determine the question of jurisdiction with finality. Counsel submitted that the intended appeal laid to the court as of right under Article 163 or A of the Constitution. Counsel further submitted that the intended appeal was not only arguable but had met all of the conditions to support a stay as initiated in the case of Munya 1. In response, Mr. Kirinyaga, counsel for the respondent, appearing with Honorable Karua, the first respondent herein, submitted that contrary to the assertion by Mr. Karani, the effect that the jurisdiction of the case was only mentioned tangentially at the High Court, the issue had not only been raised frontally by the applicants, but had been comprehensively argued and was awaiting determination by the trial court on the 6th of April 2018. It was counsel's contention that having been conversed fully at the High Court, it was only proper that the question of jurisdiction be determined at that forum on the 6th of April 2018. Counsel further contended that the application for stay had been overtaken by events as the High Court had already assumed jurisdiction. At any rate, argued counsel, there was already a de facto stay by the High Court until the 6th of April 2018. In response to Mr. Nyamodi's argument regarding constitutional timelines, Honorable Karua submitted that the original petition she had filed at the High Court at Kerugoya had already been heard and determined, and as such, new timelines would come into play. Hence, there could be no breach of constitutional limitation. The application before us is a unique one, in that the applicants seek to impart the jurisdiction of the High Court during the pendency of proceedings in this court. With that court, it is a right procedural principle that a party that seeks to challenge the jurisdiction of a court before which are pending proceedings is ideally do so before that court. Every superior court, when faced with such a challenge, has the competence to determine whether it is seized with jurisdiction or not. Yet here, we are faced with a situation where the jurisdiction of the High Court is being questioned in the Supreme Court, while the same issue is live before that court. Having taken into consideration the submissions of counsel for the parties, we are of the considered opinion that as the question before us is also awaiting determination by the High Court, it would be premature for us to make a pronouncement in terms of the prayers in the notes of motion. Consequently, we decline to make a determination on the question of jurisdiction, as doing so would amount to usurpation of the jurisdiction of the High Court. It goes without saying that any party that may be aggrieved by the High Court's decision would not in any way be deprived of redress, as he or she has recourse through the normal appellate process. We hasten to add that in view of the fact that this is an election petition, the proceedings before the High Court and appeals, if any, that may be preferred from its decision ought to be disposed of expeditiously. So the orders of the court are that the application for stay is hereby dismissed with no order as supposed.
Ahmed Abul Fadhi Mohammed and another.